Imagine this. It's late at night, your family's asleep, and there's a knock at the front door. When you look outside, you see flashing lights and two police officers standing on your front porch. They don't have a warrant, and they say they just want to talk. That moment and what you do next can decide whether or not you stay free or hand over your rights without even realizing it. Stick around. By the end of this video, you'll know what to say, and more importantly, what not to say when police show up at your front door in the state of Missouri. Most people don't realize this until it happens. You're at home. There's a knock at the front door. You look outside, and it's two police officers. They aren't holding a warrant. They aren't saying that you're under arrest. They're saying they just want to talk. This is what's called a knock and talk. And if you don't know your rights, it's one of the easiest ways to lose them without ever stepping outside of your house. Under Missouri law in the Fourth Amendment, your house is one of the most protected places that you have. But that protection only works if you know how to use it. When police come to your door, the rule is simple. They can knock, but that's all. They can't demand that you speak to them. They can't enter your house without permission or a warrant. And if you tell them to leave, they must leave. Courts in Missouri have been clear about this. In State v. Caddy, the court held that police officers have an implied license to approach a residence, just like any other member of the public. But that license ends the moment you say no or refuse to engage. Once that happens, any continued presence or attempt to gather evidence becomes a search under the Missouri Constitution. In State v. Cromer, police went onto private property and began snooping around after getting no response at the door. The court ruled that because the homeowner had clearly withdrawn consent by not answering, that the officer's actions violated constitutional protections. The evidence they found was thrown out. Missouri courts have followed the same principle again and again. If police officers have no warrant and no consent, their visit must be brief, limited, and polite. Anything more is unlawful. Let's break down what that means in practical terms. If you have a walkway or an open gate, police officers are allowed to approach, knock, and wait a short time. They're hoping you'll open the door and start talking. That's where most problems begin. The longer the conversation goes, the more likely the officers will be able to twist something you say into justification for a search. You might think that you're just being polite. Later, police may describe it as consent. In State v. Smith, Missouri's appellate court explained that the knock and talk technique cannot be used as a backdoor around the warrant requirement. When officers use the encounter to pressure or prolong contact after consent is refused, it crosses the line. Judges have repeatedly described these tactics as manipulative, legal only if you let them be. So what should you do if police are at your front door right now? First, don't open it. You are under no obligation to talk through the door or step outside. You can look through a peephole, a window, or a doorbell camera. Identify them, but don't engage. You can simply say, "I don't wish to speak to you," or "Please leave my property." That's enough. If they stay, record them if possible. Missouri is a one-party consent state, meaning that you're legally allowed to record the conversation or take video of police outside of your house. If you feel pressure, remember State v. Parkman. In that case, officers claimed that a homeowner gave them consent to enter during a so-called voluntary conversation. The court rejected it, finding that the consent came after sustained police presence and implied authority. The ruling made it clear. Police authority ends when your refusal begins. Once you say no, they're trespassing. Some people worry that refusing to answer will make it worse. It won't. In State v. Earl, officers knocked multiple times late at night, claiming to be conducting a welfare check. The homeowner ignored them, but they later entered and found evidence. But the Missouri Court of Appeals threw it out. Why? Because there was no emergency, no warrant, and no consent. Ignoring the knock preserves that homeowner's rights. If police claim they have a right to stay or search without a warrant, they're wrong. Unless there's an emergency, like somebody screaming for help or evidence burning, police are not allowed to stay on your property after you've refused to talk. The Missouri Constitution protects the curtilage of your home, the porch, the driveway, and the immediate surroundings, the same way it protects the living room inside. Locking your gate or posting a no trespassing sign removes even the limited license of approaching your home. Now what about drug dogs? In Florida versus Jardines, the U.S. Supreme Court found that bringing a drug-sniffing dog onto somebody's porch without a warrant is a search. Missouri courts have adopted that same reasoning. In Katy, in later cases, they've held that a dog's sniff isn't just a plain smell or casual observation. It's an investigative act requiring legal authority. So if you see officers leading a dog up your walkway, that's a red flag. You can and should refuse to open your door or grant consent. Missouri courts have also addressed what happens when officers linger or return after being told to leave. In State versus Cromer, once officers left and then returned later to look through the windows, the court found that they'd violated the homeowner's rights and suppressed all of the evidence. The takeaway is simple. When the knock ends, the visit ends. They can't camp out or come back to fish for more. Now, let's go over the 5 best ways to protect yourself during a knock and talk in the state of Missouri. First, establish physical privacy. Fences, gates, no trespassing signs. They're not just decorations. They legally reduce police access to your property. Courts view them as clear signals that entry is restricted. Second, if you choose to have open access to your door, understand the limits. Police can knock and wait briefly, but they cannot insist that you come out or continue speaking. The law gives you full control over whether the interaction happens at all. Third, withdraw implied consent quickly and clearly. You don't need to shout or argue. A calm, "I don't wish to speak," or "please leave," is enough. Once said, they must go. If they don't, that's evidence of an unlawful search. Fourth, document everything. Record video, write down badge numbers, and save any footage from security cameras. If your rights are violated, this evidence can support a civil claim later, just like the plaintiff in Fritsch v. Merrill, where officers were held liable for refusing to leave private property after consent was denied. And fifth, never try to physically stop or arrest officers yourself. Even if they're violating your rights, confronting them could escalate danger and jeopardize your case. The right move is to stay calm, document everything, and then talk to a lawyer. Missouri law gives you remedies after the fact: civil suits, suppression hearings, and complaints of misconduct. Here's the bottom line. A knock and talk really isn't a conversation. It's a fishing expedition. The less you say, the less bait they have to work with. Remember the simple rule that Missouri courts have repeated for decades. Police can ask, but you can refuse. Once you say no, their license to be there is over. So when that knock comes, stay quiet, stay calm, and protect your space. Your home is your castle, and in Missouri, the law still supports that.